this relationship has grown toxic, unfortunately, and it continues to do that. A few months ago, from our old church, over the pulpit, said that she was in an abusive relationship, meaning with me. He hates me and I'm so horrible.
Okay, let's take up the Hitchcock matter. I see a couple pleadings in the file, and there's a motion for reconsideration that Judge Fassett needs to address, and those motions I generally are just determined on pleadings alone. So, and then I see a motion to bifurcate the proceeding. Is there anything else I need to address today?
That's it.
I think that's it, Judge.
Okay. So, Mr. Hitchcock, this is your motion. Go ahead. If there's anything you want to say besides what you submitted.
Just that this relationship has grown toxic, unfortunately, and it continues to do that, become more toxic and more bitter. And a bifurcation would be in the best interest of both parties for their mental health. There's a number of things that we won't get into now, but like there's just incredible bitterness from, and hurt on both sides. And Megan's continued to do things and that have hurt me, and I can do, she's been hurt, and it would be very good for me to have this marriage legally ended. We've been separated for over 3 years, and every step has been a fight. I don't know why this step has been a fight. I'm just asking that we legally dissolve the marriage, as going to trial will take another year from what I understand. And there's animosity being attached to this woman who continues to do things that hurt me, and she feels hurt. She recently, a few months ago, from our old church, over the pulpit, said that she was in an abusive relationship, meaning with me, but we haven't.
Your Honor, to object to anything that's not before the court.
This has been reported to me, and I mean, we're not in a relationship. The fact that she uses me to say she's in an abusive relationship, I've never been abusive to her, and I want to bifurcate this divorce. I want it to be legally ended, and I don't understand. I really believe the opposing party lawyer is drumming up business for himself. I mean, Megan's got to be spending over $600 for this, for no real reason. How does she have it both ways? She hates me and I'm so horrible, and she doesn't want to bifurcate the divorce.
All right. Thank you. Mr. Zandy, any response?
Yeah, and I guess I'll start with the obvious. As far as drumming up business, that's the last thing I need to do. I think the family law attorneys in the local area are beyond overworked, and there's a lot of business to go about. And certainly this case is not necessarily one that has gold mine at the end of it. We're doing this because unfortunately we're here on, again, actions of Mr. Hitchcock, which continue to abuse the court system. Now we're here on a motion to bifurcate, and there's no legal or factual basis to do that. I would certainly wager to say that anybody going through a dissolution action would love to bifurcate their divorce and just simply be resolved after 90 days, but that's not the reality, and that's not what the law sets forth. Now, we have given you the basis for bifurcating cases and divorces, which states it's generally, and that's the little case, that it's generally disfavored, absent some agreement and factors which would warrant said request. That's done when there is a certain agreements on material aspects of the case and not on others. That certainly doesn't qualify here. This is one where Your Honor has not heard the majority of the motions that have been brought by Mr. Hitchcock, but he was warned last spring after he filed a motion to compel without requesting discovery or conducting a CR 26I conference. He has later filed motions to set aside restraining orders. He has generally lacked and grasped understanding of how this process works, but unfortunately that has not stopped him from filing frivolous motions. And this is, again, just the latest
objection. It was never said that those were frivolous motions.
The argument is this one is. The argument would be that this needs to fall under that category because, again, pursuant to that, there is no legal basis and there's no factual basis. If the court was to grant his order, which essentially says the case is bifurcated, the parties are divorced, there's implications on that for taxes, property, debt, parenting plans, there's insurance inquiries that go into that. And if the court just says, okay, you're divorced without a decree doing that and finding the marriage irretrievably broken, that would be in significant error and would potentially jeopardize both sides' rights under insurance, taxes, and the like. In my review of Mr. Hitchcock's declaration, it looks like the sole reason he wants to bifurcate the case is so that he can date, quote, Christian women. Again, that hasn't stopped him in the past. We've provided you information from some of his pursuits in which we have no idea who they are, but they reach out and send my client random notes that say, hey, I'm glad there's a restraining order. This guy is outside of his essential mind. And again,
Objection, that's not what was said.
That was spontaneous and sent to my client. We filed that previously. And again, I'm paraphrasing, but that was the gist of it. And to suggest that I want to be legally divorced for no other reason so I can date other women is unfounded and it's not supported by law.
Objection, that's the 12th thing I said.
All right. Mr. Hitchcock, I understand you may not agree with this. I'm going to hear the argument.
Yeah, and I'm just saying that I object that he said that the main reason I wanted was to.
Noted. And go ahead, Mr. Zandy. Anything else?
Yeah, so if you look at the basis again for a bifurcation motion, this doesn't quantify or qualify under that. And this is an individual who unfortunately has been sitting here patiently for 15 months, who was ordered to undergo a mental health evaluation, and we still have nothing related to that. I've sent requests, I provided those to you as part of my exhibits to my client's declaration, which show, despite multiple requests, multiple inquiries from the court, we have nothing related to his mental health evaluation that was ordered nearly 15 months ago. That's unfortunately been the hang up on this, to grant a motion to divorce these people when there's material issues that still have to be resolved, which are directly impacted by that order, just for the sole purpose of Mr. Hitchcock going out on and pursuing his Tinder dates or whatever it is he plans on doing, again, is
Objection.
In error of, would be an error. So that's my argument. We are asking that you find a CR 11 sanction. Again, it seems extremely frivolous. My client has paid money, and again, unfortunately, her fees are the direct result of Mr. Hitchcock continuing to file motions such as these. So we do believe that a strong message should be sent. And I think the only way to do that is through financial recourse. The court has imposed, by my count, up to about $3,500 in total fees that he was ordered to pay in the past. And to date, he just hasn't done it. We're also asking that you set a date certain for him to pay his fees, and also require an order that says the court should review and approve any proposed motion that he wishes to file. We now have this motion, which is pending, and we have a motion to reconsider, which is pending, which is ironically related to tax issues, which are directly impacted by a bifurcation motion. So again, if you look at it logistically, it makes zero sense. And it's due by design of Mr. Hitchcock, and it's abusive litigation. I mean, that's the only way you can really detail that. And it absolutely needs to stop. And we're asking the court to, again, enforce its prior ruling from the spring, in which it said this isn't going to be tolerated any further.
Your Honor, I don't believe most of what Mr. Zandy is stating. So he's arguing that Megan wants to stay married, so we file taxes together. That's not a reason to stay married. That's not a reason to put us through the mental anguish of being legally connected to someone who hates, maligns, badmouths. Once again, I mean, we're talking so, and Washington does allow bifurcation. All the states do. Washington doesn't as much, but it does allow bifurcation. This isn't a frivolous motion. This is a legal motion that I've set forth, and I'm surprised that they brought it to court. I thought it was going to be signed. But once again, I think the main thing that Mr. Zandy is saying is that there's potential money things. Like, even if we weren't married, if we had never been married, there still would be the same laws in place. I'm not asking for anything other than to be divorced, because it's bad for my mental health, and I don't believe it's good for Megan's. Once again, she's saying like, oh, I'm in this horrible marriage. Like, you're not in a marriage. We've been separated for 3 years. And I find the Tinder date thing offensive. And once again, he said that
it's been argued that the main reason is to date other people, but that's the 12th thing I've listed on a list. I mean, Megan has a 6-page declaration and I have 13 bullet points. I'm just asking to be divorced from this woman. That's it.
All right. Bifurcation is not a process or a procedure that's favored in Washington.
It is under toxic situations though.
Hey, wait a minute. You're done talking. I gave you plenty of chance to talk already. So at this point, bifurcation is not favored in Washington. I don't see a benefit, and it has a lot of potential consequences that Mr. Hitchcock, I think, frankly, you just probably don't appreciate. And if you're representing yourself, you end up being held to the same standard as an attorney, which admittedly is a tough thing, I think, sometimes for pro se litigants, but there has been a review of the file, just a number of motions that seem to be without basis. This is a motion that I don't see as having really any basis, legally or factually. I am going to impose $500 in legal fees payable to the office of Chad Zandy. Those fees need to be paid by December 1st. In terms of any order regarding Mr. Hitchcock and filing motions, I guess, is that just a request you're making here? Because I didn't see that in your pleadings.
No, I think if you look at the last page of my client's declaration, it was there. That's on page 5, line 13 through 15. I would also ask the court to require Mr. Hitchcock to have any motions filed on his behalf reviewed and approved by the court prior to filing and serving those. Then my client details the significant resources she spent responding to motions such as this. And it's gotten really bad since late last winter, and now obviously here we are on another kick of bifurcation motions and motions to reconsider and such that, frankly, my opinion, I don't see a lot of legal merit to. And I just want to avoid that if we can. And I think this is the only way to curb that. I realize that it's kind of an extreme measure, but I think we've broached that point. I think that's probably the only way to curtail some of the abuses.
I'm looking at the declaration that was filed October 2nd.
That's the motion to reconsider, Judge. This one was filed on September 22nd. So the one you're referencing on October 2nd was filed in for the motion to reconsider, which should be in front of Judge Bassett. He's asking the court to reconsider her decision from a month and a half ago or so.
That's legal.
I'm going to enter a separate order that does require court to approve.
Your Honor, can I speak?
No, not until I'm done with this. All right. Any motion that Mr. Hitchcock wants to file needs to be sent to Superior Court Admin at Cowlitz.gov, excuse me. And I'm going to need to revise this, so I'm going to rewrite this, but the court will review the pleading and determine that it's not frivolous prior to the document being filed and served. So Mr. Hitchcock, what that means is you're going to need to email anything you want to file with the court to that email address. A judge will review it and determine whether it's appropriate to move forward, whether there's a colorable argument or a valid argument that's being made. And in these situations, the court will probably err on the side of allowing you to file the document, but there needs to be, at this point, there's been enough what appears to me to be frivolous litigation that the court needs to, and fees, the imposition of a number of fees have done nothing to change that. So this is an extreme remedy, but I think in this situation it is justified. I'm going to enter an order that's substantively what I just announced. I just need to rewrite it and give it a little more thought before I actually finalize it. That should be an odyssey within the next day.
And you said I could speak, but I did talk to Judge Bassett about this in Megan's previous motion. and it was said that I would have to bring it forth in an actual motion, which I did, which is what she said I would have to do.
Okay. And I don't think this is inconsistent with that. I'm just taking it an extra step now that I've reviewed the motion that you filed. She didn't have the motion in front of her, but now that I've reviewed it and reviewed the response, I think this is appropriate given the overall context of the case. So that'll be the order of the. So I'm going to be entering two orders. One order that imposes $500 in legal fees to the office of Mr. Zandy, payable by 12/1/23, and the other order requiring you to file any pleadings or have any pleadings reviewed by sending them by email to the court before they're filed.
In the first order, Judge, are you, I'm assuming, specifying that the order to bifurcate is denied and is frivolous? Okay.
It starts out, Mr. Hitchcock's motion for bifurcation is.
Okay, thank you. And I don't know if we were going to hear from Ms. Pike or not. Somebody asked something, maybe that was on Mr. Hitchcock's end.
Oh,
Ms. Height, do you have any information you thought was germane to this?
I do not, Your Honor. Thank you.
All right, thank you.
Thank you.